and welcome to today's Employment Law Update with Keeley Baigent of KSAB Law. Today we're going to cover case law developments in the areas of menopause discrimination, disability discrimination, sexual harassment and unfair dismissal. We're also going to cover recent legislative developments in the areas of flexible working, bullying, neonatal leave and parents' redundancy protection. The session today will be recorded and sent to you in the next week. Please do feel free to ask questions as we go along in the chat box, and I'll ask them to Keeley for you as we move through the session. So I'll pass through to Keeley, and I hope you enjoyed the session today. Some of those things, Keeley, I didn't even know existed, I have to say.
Yeah, so there has been quite a few developments since our last update in March. And some of them really interesting, actually, and some of them not particularly highlighted in the media either. So there might be things that you think, oh, that seems quite important, but I've not heard of that. So let's hope that I can update you on a few things that have happened. I'll also talk about trends that I'm noticing and that you may well be noticing as well. And the big one is around mental health again. Lots
in social media about it at the moment.
And complications because of that, and people feeling happier, more at ease to express their mental health issues that they may be suffering from. And that having an impact, not only in the education sector, but also in the workplace. So the first case that I want to talk to you about is a relatively recent case relating to menopause and discrimination. And I'll share my screen so that you can have a look at the slides as we go along. It's the first case of Linsky and Direct Line Insurance Services Limited. So as we know, there is no protected characteristic of menopause. The government rejected that request from some MPs that lobbied for it around a year ago. So we're left with the other protected characteristics that a claimant needs to rely upon in order to bring a claim relating to disability or sex or age, and, as I say, associated with or relating to the symptoms of menopause. So if a claimant, a woman, suffers, they believe, some discrimination, some less favourable treatment on the ground of menopausal symptoms or perimenopausal symptoms or postmenopausal symptoms, then the protected characteristics that they're going to be relying upon are firstly age, on the basis that menopause only affects women of a particular age. Alternatively, the protected characteristic of sex, because of course menopause only affects women, and also the protected characteristic of disability, on the basis that the employee's menopausal symptoms satisfy the definition of disability in the Equality Act, Section 6, which we all know and love to be a mental or a physical impairment which has a substantial and long-term adverse effect on the employee's ability to conduct day-to-day activities. And I must say, the more menopause cases that are coming through the tribunal, the more they are relying upon disability rather than age or sex. The claims that will be pursued by a claimant in relation to discrimination and relating to the symptoms of menopause could be direct discrimination, which, as we know, is where an employee is treated less favourably because of the protected characteristic, that being age, sex or disability. Or it could be the category of harassment, where the conduct is related to the protected characteristic, so related to age, sex or disability, and it has the purpose or effect of violating the employee's dignity or creating an intimidating, hostile, degrading or offensive environment for the employee. Also, a claim might refer to the category of discrimination being failure to make reasonable adjustments, where any provision, criteria or practice places a disabled person at a substantial disadvantage. And then lastly, the claim might relate to the category of discrimination arising from disability, where an employer treats the employee less favourably because of something arising in consequence of the employee's disability, which cannot be justified. So, for example, dismissing an employee because of their sickness absence, which results from their disability. So that's discrimination arising from disability, not on the ground of disability. It's because of something that results from the disability itself. Another relevant claim might well be constructive unfair dismissal. And this, of course, occurs where an employee can show, so the onus of proof is on the employee to show that they resigned because of a fundamental or a repudiatory breach of contract by the employer. And that fundamental breach of contract could be a breach of the term that's implied into all contracts of employment, that an employer must not act in a way that undermines the trust and confidence in the employment relationship. So they're the particular claims that an employee might bring if they are pursuing a claim relating to their symptoms of menopause. So let's have a look at this case then. Mrs. Linsky worked for Direct Line Insurance Services Limited as a telesales consultant from 2016 until her resignation in May 2022. She received good performance ratings the first 4 years of her employment. However, in 2019, she started to suffer from menopause symptoms, which adversely affected her work performance. During her employment, those symptoms included low mood, anxiety, mood swings, poor self-esteem, effects on memory, and poor concentration. The onset of Mrs. Linsky's symptoms coincided with the introduction of a new initiative, which involved retraining all the sales accountants, consultants, including Mrs. Linsky herself. In March 2022, Mrs. Linsky's GP diagnosed a hormone imbalance, depression, and low mood, and prescribed antidepressants. Mrs. Linsky documented the effects of her menopause symptoms and the treatment she was receiving in her development notes, prepared for her one-to-one meetings with her manager. In June 2020, Mrs. Linsky's manager raised concerns with her about her conduct on a particular customer call, which Mrs. Linsky agreed wasn't acceptable. A success plan involving weekly coaching was put into place, and Mrs. Linsky's manager sought advice from the more senior operations manager, who suggested Mrs. Linsky be offered a different role in the telematics team that had become vacant. The operations manager offered Mrs. Linsky the role as a better fit for her, as it did not have the challenges of a sales role. And Mrs. Linsky accepted the role, although it did not include the sales-related bonus she had previously enjoyed. Mrs. Linsky began working in the telematics team in July 2020 and received training from a colleague. She spoke with her manager daily and sought regular advice on Teams, as the team were working remotely during the COVID pandemic. Mrs. Linsky initially did well in the role and gradually came off her antidepressants. However, in November 2020, there were 2 further customer complaints where Mrs. Linsky had been abrupt and rude on the call. Mrs. Linsky advised her manager that she felt coming off her medication may not have been the right decision, and she was given further training and coaching, although the manager considered the conduct on the calls was behavioural rather than meeting performance standards. So they dealt with it as a performance issue. In Mrs. Linsky's end-of-year review for 2020, her manager stated that she was struggling to get to grips with and understand the role. She required a high volume of support and seemed to struggle to retain information or learn from questions asked previously. However, she recognised that Mrs. Linsky wanted to do well and showed great passion and commitment. And for the first time, Mrs. Linsky was graded as need for improvement, which meant that she did not receive a pay rise. Mrs. Linsky received further training in January 2021 and received good feedback on her performance in February 2021, although there was some further problematic calls in February and March. So we're now nearly 2 years on. In April 2021, then, Mrs. Linsky's manager coached her further by listening on to calls. The manager sought advice from HR on how to deal with Mrs. Linsky's continuing performance issues, but at that point did not mention to HR the menopause symptoms. A disciplinary meeting was held on 30th of April 2021, and Mrs. Linsky was given a first written warning under the performance process. And there was a further success plan to run for 3 months. So that's the monitoring for 3 months. In the decision, the manager recorded that Mrs. Linsky had advised her that she had experienced menopause symptoms since January 2020, and that these impacted on a person's ability to retain information, caused brain fog, and impacted emotional instability. However, the manager stated that she could not accept this as mitigation for Mrs. Linsky's underperformance because she had taken on a new role despite her symptoms, had taken the decision to stop taking antidepressants, and had only consulted her GP again very recently. Mrs. Linsky's mental health understandably deteriorated after receipt of the written warning, and she was diagnosed with stress by her GP. She continued to attend work, however, and be performance managed under the success plan. In mid-July 2021, she was signed off work, however, due to stress, and Mrs. Linsky was trying to manage her stress and menopause symptoms by counselling, acupuncture, and changing her diet and exercise. She attended a menopause advice session at the recommendation of her manager and received counselling through the employer's assistance programme. On 20th of August 2021, Direct Line referred Mrs. Linsky to occupational health. So they don't get occupational health involved until August 2021. The occupational health expert advised that Mrs. Linsky was likely to be disabled, would be unable to return to work for a further 6 to 8 weeks, and would then require a phased return. Occupational health also recommended an open dialogue about stress, a review of training needs, additional training time, and an adjustment to target-based work until Mrs. Linsky's menopause symptoms had improved. The report also noted that Mrs. Linsky was unable to take hormone replacement therapy and was not taking any other medication. Direct Line sick pay policy provided that after 5 years of service, an employee could receive 26 weeks of full pay in any rolling period of 12 months. And on the 15th of September 2021, Mrs. Linsky was advised.
On the 15th of May, someone's left a bad review on our website. Who can it be? 15th of May. Yeah.
I can hear somebody talking. Would they mind
I've muted. Keeley, it should be okay now. I've muted.
Okay, that's fine. I didn't know whether it was a question or whether they were just okay.
No, I don't think so.
So her company sick pay was withdrawn after 13 weeks, despite the 26 weeks being a recommendation or being a discretionary element of the sick pay provision. She raised a grievance in November, alleging discrimination in connection with the disciplinary warning, the sick pay decision, and other matters. And following an investigation, grievance hearing, and appeal, Mrs. Linsky was awarded a further 13-week sick pay on the 30th of March 2022. However, the warning was not withdrawn, the appeal chair reasoning that it would have expired by the time Mrs. Linsky returned to work. Mrs. Linsky remained off sick with stress and anxiety. Lo and behold, then, she resigns on the 3rd of May 2022, referring to the treatment she had received over the previous couple of years. Direct Line's failure to make reasonable adjustments and alleging disability, age and sex discrimination. And then she pursued her claims of constructive unfair dismissal and disability, age and sex discrimination in the Employment Tribunal. So before we look at that decision, just on the disability issue, at no point during the time Mrs. Linsky was employed or at the beginning of the Employment Tribunal proceedings did Direct Line admit that they accepted that Mrs. Linsky had a disability that met the definition in the Equality Act. And it actually wasn't until January 2023 and just before the hearing, which took place in March this year, that they accepted that she had a disability and that they had knowledge of that disability. So they delayed until, as I say, right before the hearing. So what do you think then? Do you think Mrs. Linsky's claims succeeded? Let's have a look. So Mrs. Linsky's age and sex discrimination claims were not upheld. And also her claim of constructive unfair dismissal wasn't upheld, but I'll touch upon that in a minute. However, Mrs. Linsky's claims for discrimination arising from disability and failure to make reasonable adjustments were upheld. So first, we're then looking at the discrimination arising from disability claim. The tribunal held that the 2020 annual review performance rating of need for improvement amounted to an act of discrimination arising from disability. The Employment Tribunal noted that Mrs. Linsky's manager had recorded in the performance review that Mrs. Linsky struggled to retain information. And this was as a result of Mrs. Linsky's menopause symptoms of inability to retain information and poor memory. The assessment and consequent lack of pay rise, which resulted from the recommendation of need for improvement, were therefore something that arose from Mrs. Linsky's disability or resulted from it and were in consequence of her disability. And the tribunal took into account the following. Mrs. Linsky had previously had good performance ratings for the previous 4 years. She had informed Direct Line of the reasons why she was now struggling to retain information. It was accepted by Mrs. Linsky's manager that her conduct on the 2 calls, which resulted in the complaints, was unintentional and as a result of the symptoms that she was suffering with. And the assessment had direct financial impact on Mrs. Linsky's pay. The tribunal held that Mrs. Linsky could, in those circumstances, reasonably expect some reflection on whether she should be given the benefit of the doubt, rating her performance as good in the sense that she was doing all she could to achieve within her limitations. Need for improvement is inherently unfavourable if the person through disability cannot, in fact, improve or meet the required standards. The tribunal further upheld Mrs. Linsky's discrimination arising from disability claim in relation to the written warning in April 2021. And they applied the same analysis that they did in respect of the other matter, the need for improvement assessment. So the warning was unfavourable treatment because of something arising in consequence of Mrs. Linsky's disability. The menopause and her symptoms had been mentioned many times by Mrs. Linsky at the disciplinary meeting. The tribunal concluded that a less discriminatory approach could have been adopted in dealing with these matters and dealing with Mrs. Linsky's performance issues. And they also said that the employer should have taken into account Mrs. Linsky's disability as a mitigating factor during the disciplinary hearing, which obviously they refused to do, if you remember. The tribunal also said the decision to cease sick pay was also an act of discrimination arising from disability. So those are the three things it held were acts of discrimination: the 2020 annual review performance rating of need for improvement, the April 2021 written warning, and the decision to cease company sick pay. Also, they held, in relation to the failure to make reasonable adjustments claims, that Direct Line ought to have known about Mrs. Linsky's disability back in March 2020, when she first advised her manager of her menopausal symptoms, and should have obtained an occupational health report at that stage. So right at the start, the tribunal said they should have obtained occupational health report. The Employment Tribunal held that from April 2021, Direct Line's criteria of requiring Mrs. Linsky to meet the performance standards of her role placed her at a substantial disadvantage because of her disability, and reasonable adjustments therefore should have been made to assist her. The disadvantage Mrs. Linsky faced in meetings the standards of her role while struggling with her menopause symptoms should have been recognised, and adjustments should have been made. The Employment Tribunal said that the adjustment should have included a consideration of the following: being given a non-telephone role, call time and other targets being reduced, the disciplinary process could have been abandoned, and Mrs. Linsky's mitigation that she was disabled could have been accepted. So those were reasonable adjustments that the tribunal said should have applied or could have been considered. And with regard to Mrs. Linsky's constructive dismissal claim, although that didn't succeed, it didn't succeed on the basis that Mrs. Linsky had delayed too long in resigning. But in fact, if she had resigned earlier, after, in particular, the refusal to reduce sick pay, the decision to reduce her sick pay, then it probably would have succeeded, because the manner in which she had been treated did breach and undermine the implied term of trust and confidence. So she could have succeeded in that claim if she had resigned earlier. What was her remedy? Her remedy was at £64,645, including £23,000 for injury to feelings. So that's middle band injury to feelings award, and that relates to the gravity of the discrimination and the impact it had on the claimant. The tribunal also awarded Mrs. Linsky £2,500 in aggravated damages, and that was because the tribunal said they had the information that Mrs. Linsky was disabled in accordance with the Act well before they actually accepted that Mrs. Linsky had a disability, and they shouldn't have delayed so long in accepting the issue of disability. So quite a bit, I think, we can learn from this case, and that's why I've spent a bit of time on it. The decision illustrates, doesn't it, the difficulties that an employer can face in dealing with employees' performance if it is related to a disability, including symptoms of menopause, which of course can, and in this case were, determined to be a disability. It's interesting that the tribunal said you must get an occupational health report as early as possible. So I think that's definitely something that we need to take from this. And the controversial statements of the tribunal that a formal performance management process may not be applicable or reasonable to apply to an employee with a disability. So please be careful that if you have an employee who has got a disability, whether that's menopausal symptoms or something else, then question whether or not, and that's impacting on their performance, then question whether or not a formal performance capability process is the right way to deal with the performance issues. Get your medical report and then make a decision as to what is the most fair and reasonable course of action to take in dealing with the performance issues. Of course, the performance issues will need to be dealt with, but the tribunal is saying perhaps not through a formal capability or performance process. It's key for managers to be trained. Obviously, the manager did her best in dealing with this matter. She clearly wasn't trained in matters of disability or matters relating to menopausal symptoms and whether or not they could or couldn't be a disability, and the employer lost the case because of the manager's actions. So obviously training for managers dealing with these matters is going to be key. And then the other point to take from this is don't delay in accepting an employee has a disability until the very last minute in tribunal proceedings if there is sufficient evidence to suggest that the employee has got a disability. Most employment lawyers will deny the issue of disability at the outset of proceedings, but that may not be the correct and might not be the correct and most financially reasonable way to deal with the case if there is sufficient evidence. In this case, it was an occupational health report that stated clearly that she could be disabled. And there was also a lot of evidence to indicate that the symptoms she was suffering had a severe impact on her ability to conduct day-to-day activities. So an interesting one, I think, and one that we can take a lot from. Moving on then to the next case in the area of unfair dismissal and, again, disability discrimination. And it's the case of Borg, Neil and Lloyds Banking Group. In this case, the Employment Tribunal had to determine if a manager who used an offensive racial term in a race awareness training session had been unfairly dismissed and discriminated against because of something arising from his disability. So again, we've got this category of discrimination arising from disability. So discrimination, less favourable treatment as a consequence of something that results from the disability. The background to the case then is that, as we all know, if an employee has 2 years service or more, they will be protected from being unfairly dismissed. And they could bring a claim for unfair dismissal if, as I say, they have 2 years service or more. That's ordinary unfair dismissal under the Employment Rights Act. The dismissal of an employee will be unfair if they've got 2 years service or more, unless the employer can show, so the onus of proof is on the employer to show that the reason or principal reason for the dismissal was one of the 5 potentially fair reasons listed in the legislation, and that in all the circumstances of the case, the employer acted reasonably in treating that reason as a sufficient reason to justify dismissal. So that's where we can look at procedure and the reasonableness of the sanction in the circumstances. One of the potentially 5 reasons to dismiss an employee for is, of course, misconduct or conduct. However, a dismissal for misconduct will only be fair if at the time of the dismissal, the employer believed that the employee was guilty of misconduct, that the employer had reasonable grounds for believing that the employee was guilty of the misconduct, and at the time it held that belief, it had conducted a sufficient amount of investigation, or as much investigation as was reasonable in the circumstances. And that comes under the case of BHS and Birchall. That's the BHS and Birchall test that applies in a misconduct case. So in this case then, it also concerns, as I say, discrimination arising from disability, which we've already looked at what that category is. And as I said, it's where an employee is treated less favourably because of something arising from the employee's disability, which cannot be justified. The facts of the case then are that Mr. Borgneal was a long-standing employee of Lloyds Banking Group PLC. From 2011, he was employed in the bank's Payment Design Authority as PDA manager. So he was at manager level, and he was, as I say, a long-standing employee. On 16th of July 2021, Mr. Borgneal attended a remote training session titled Race Education for Line Managers. This training was part of a race action plan, and it was launched by the bank in 2020. The training was provided by an external training company, APS Intelligence. During the session, Mr. Borgneal asked how a line manager should handle a situation in which they hear someone from an ethnic minority use a word that might be considered offensive if used by someone not within that minority. When he did not get an immediate response from the trainer to the question, he added, the most common example being the use of the N-word in the Black community. However, Mr. Borgneal used the full word rather than the abbreviation. After the session, APS reported Mr. Borgneal's use of the language that he used, the comment that he made, to the bank. And following an internal investigation, the bank decided to pursue formal disciplinary action against him. The bank concluded that Mr. Borgneal did not intend to cause hurt or offence, that he asked the question without malice, and that the question had been valid. However, it found that he should have known better than to use the full word in a professional environment, and he should have realised that this would cause serious impact, which it had done. Although Mr. Borgneal had apologised immediately and had not repeated the word, APS had told the bank that the trainer had been off work for 4 or 5 days after the training session. Consequently, it dismissed Mr. Borgneal for gross misconduct. On 17th of December 2021, his appeal against his dismissal was rejected on 15th of August 2022. So it took over 6 months to deal with the appeal, which is rather interesting, isn't it? Anyway, so Mr. Borgneal brought claims against the bank for, among other things, unfair dismissal and discrimination arising from disability. Do you think the claims were upheld? So, the unfair dismissal claim was upheld. Firstly, the Employment Tribunal held that Mr. Borgneal's actions did not amount to gross misconduct. The tribunal accepted that the bank actually believed and genuinely believed that Mr. Borgneal had committed gross misconduct by making the comment, but it held that the bank did not have reasonable grounds to consider that the comment amounted to gross misconduct. So again, reasonableness came in, and the tribunal said it wasn't reasonable for the bank to have held that the comment actually amounted to gross misconduct. The tribunal also held that the bank had failed to conduct a reasonable investigation. So the Birchall test wasn't satisfied in this case. And in deciding this, the Employment Tribunal took into account the following factors. First of all, the fact that Mr. Borgneal had said the word only once and had immediately apologised. His question was relevant and well-intentioned, and he had not used the word as a term of abuse, but simply to ask how to deal with a particular situation. Also, the training session had begun with a script which warned against the use of language, but several participants, including Borgneal, hadn't been there at the beginning of the course before the beginning of the session, so hadn't seen that script. Further, the Employment Tribunal had concerns about the evidence the bank had relied on to demonstrate the distressing effect of Mr. Borgneal's actions on the people in the room. For example, the bank hadn't interviewed the trainer directly. They had just taken the word of the company that the effect on the trainer had been to result in this 4 or 5 days absence. And they hadn't interviewed anybody else in the room and asked them how they had felt or how the comment had impacted on them. Also, 2 other trainers who had been present for the session had made no direct complaint about the comment made. So on this basis, the Employment Tribunal said that the bank had failed to conduct a reasonable investigation and therefore hold a reasonable belief that Mr. Borgneel had committed an act of gross misconduct. Also, the tribunal said the sanction was unreasonable. It wasn't within the range of reasonable responses of a reasonable employer to have dismissed Mr. Borgneel in the circumstances it did. And it could have achieved its aims of ensuring that there was a zero tolerance of race discrimination by simply issuing Mr. Borgneel with a written warning. That probably would have achieved the desired outcome rather than jumping straight to dismissal, which, as I say, was determined to be unreasonable in the particular circumstances. In effect, the tribunal said that no reasonable employer would have dismissed Mr. Borgneel in these circumstances, and therefore the dismissal was unfair. In the case, the Employment Tribunal also held that Mr. Borgneel's dismissal amounted to an act of discrimination arising from disability. Now, this is interesting. So, Mr. Borgneel had the disability of dyslexia. The tribunal found that the evidence made it clear that Mr. Borgneel was on occasion unable to properly express what he is thinking because of his dyslexia. On the balance of probabilities, it found that his dyslexia was a strong factor causing how Mr. Borgneel expressed himself in the session and in his use of the full word without finding a way to avoid it. And therefore, the tribunal said that the dismissal, which is obviously the less favourable treatment, was something that arose as a consequence of Mr. Borgneel's disability, the dyslexia, and his inability to express himself in the way that a non-dyslexic person may have been able to express themselves at the session. And the tribunal went on to say the dismissal wasn't justified because a warning would have done and achieved the same thing. By ensuring that the bank was making it clear that they had a zero tolerance of race discrimination in the workplace. I think the case was really interesting, mainly because of the dyslexia issue. I've had recently a few cases where employees have said, well, my behaviour or my poor performance is as a result of the symptoms of my disability. And therefore an employer is being expected in those circumstances to consider that and make allowances in some circumstances to take into account those disclosures. And is clearly indicated in this case that by failing to take into account the disability of dyslexia in this case did amount to an act of discrimination. Yeah, and in the case judgment, in the judgment, it is made clear that this is very much a case specific on its facts. And yes, in most cases, if racist language is used in the workplace, dismissal is the outcome because it's gross misconduct. But still, what we as employees have to do is consider all the circumstances and consider any mitigating circumstances and consider the particular facts relating to when the comment was made or the abusive behaviour took place to ensure that the sanction is reasonable in the circumstances. Okay, so moving on then to the next case, we're going to have a look at sexual harassment area. The case is that of Christine Rogers against the Ministry of Defence. In this case, the Employment Tribunal had to determine if the claimant, Christine Rogers, had suffered sexual harassment. The background to the case is, of course, the definition of sexual harassment, which occurs when a person engages in unwanted conduct of a sexual nature, which has the purpose or effect of violating the claimant's dignity or creating a hostile, degrading, humiliating, or offensive environment for the claimant. In determining whether the conduct has got that required effect, the Employment Tribunal will, of course, consider the perception of the claimant, but it will also consider, in the circumstances, whether the conduct complained of can reasonably be construed as having the required effect. So the reasonable test does come in. Is the perception of the claimant reasonable in the circumstances? If therefore a claimant is held to be being hypersensitive, or if the tribunal, say, determines that actually it wasn't reasonable in the circumstances for the claimant to have the perception that the comment or behaviour amounted to sexual harassment, then the claim will fail. So the facts of this case are that Mrs. Rogers claimed sexual harassment against the Ministry of Defence related to comments made to her by a senior army officer, namely Lieutenant Watkins of the MOD's School of Transport. The comments made by Lieutenant Watkins included a remark that Mrs. Rogers was a clever woman, but she could be manipulative. Mrs. Rogers also told the tribunal how Lieutenant Watkins had accused her of having a problem with robust banter and that she didn't like men. Following the comments made, Mrs. Rogers brought a claim of sexual harassment in conjunction with an unfair dismissal claim following her dismissal. She alleged that the comments were related to sex and had created a hostile, degrading, humiliating, or offensive environment for her. What do you think? Do you think the comments amounted to sexual harassment? No. The tribunal held that the comments didn't amount to sexual harassment. The employment judge Lancaster stated in his judgment that regarding the clever woman comment, Lieutenant Watkins need not have referred to Mrs. Rogers as a woman, but in doing so, it is quite evident that Lieutenant Watkins did not have the purpose or intention of violating Mrs. Rogers' dignity or creating a hostile, degrading, humiliating, or offensive environment for her. Judge Lancaster went on to state, and equally viewed objectively, the comment cannot reasonably be construed as having the effect of creating a hostile, degrading, humiliating, or offensive environment for Mrs. Rogers. Employment Judge Lancaster also referred to evidence that supported Mrs. Watkins' hypersensitive character. So what can we learn from this? That sometimes in the tribunal, common sense does prevail, firstly, but this is testament, this case, that a hypersensitive claimant will not succeed in a harassment claim. And when considering whether comments could amount to acts of harassment, the reasonableness of the claimant's perception is really important to consider. Next case, then, to touch
Keeley,
upon. Yes.
Sorry, just before you move on, I've just got
Yes.
a question.
Yes.
So not on the last case, but the one before.
Okay.
Do we know whether the disability was raised at the time of the investigation prior to this dismissal? So did the ER know of the disability?
Which case are we talking about? Sorry.
Meg, did you want to unmute and ask the question?
Hello. It was with regards to the dyslexia discrimination. Did the employer know that they suffered with dyslexia when they were investigating it at all?
Yes, I think they did. They would have had to have done for the claim to proceed. As part and parcel of the proceedings, the judge would have had to have decided whether or not the claimant had a disability and whether or not the employer had knowledge of the disability. And only then will a disability discrimination claim proceed. So yes, the judge will have found that the employer knew about the disability, but what they obviously did is choose to ignore it, and say that they didn't believe it had any consequence on his inability to express himself in another way in the session.
Thank you.
I'm just conscious of the time, so I am going to miss out this case because I'm going to I'll send you the slides, Eloise, and then perhaps we can people have a look at it in their own time, and then they can pose any questions that they want to. It's not one that I think highlights any huge issue that I want to bring your attention to. Only again, I suppose, just to take it takes into account the fact that this employee had a disability, and he said that his behaviour, which was appalling, he was swearing at his managers, he was being undermined their authority in a number of ways, which you'll see on the facts. He was dismissed for that, and he tried to argue that his inappropriate behaviour, and really quite, as I say, terrible behaviour in the workplace, was as a result of a bipolar disorder he was suffering with. And the tribunal in that case saw sense and said that we don't think it was connected on the medical evidence, and by the claimant's own admission during the hearing, the behaviour was not attributable to the bipolar disability, and therefore, as a result, we're not going to uphold that claim of disability discrimination. The employee did succeed in his unfair dismissal claim, but that was only because the employer failed to hold a full disciplinary hearing and didn't allow the employee to appeal, because I think at that point they were so exasperated by the employee that they thought, we're not even going to follow a procedure, we just need to dismiss him. So, but he was awarded no compensation at the employment tribunal hearing, because the tribunal held that even if a fair procedure had been followed, he would have been dismissed in any case. And also because of his contributory fault, his actions had substantially caused his dismissal, and therefore his compensation was awarded at 0. So it's an interesting case in so much as I think the bipolar element, disability element he was trying to argue resulted in his behaviour for which he was dismissed. So again, a link with the disability issue, which we're seeing a lot of, which is what I said right at the beginning. These cases do seem to be coming through. So that's that case. And then I'm going to just jump onto this very funny case at the end here of the section on case law. So this case is about sexual harassment. It was a case where the employment tribunal was required to determine whether or not the content of an email amounted to an act of sexual harassment, and in particular whether it constituted conduct of sexual nature. The facts of the case are that Mrs. G worked for SDocs, a company specialising in digital trade management solutions, from 2019 until her resignation in July 2021. She told the Central London Employment Tribunal that an email she received using XXYY and 4 question marks constituted a sexual advance. And the basis for this was that the XX apparently referred to kisses, YY denoted sexual contact of some nature, and the 4 question marks was a coded way of Mrs. G's boss, Mr. Goulandris, asking her when she would be ready to engage in sexual acts with him. The email followed a number of alleged touching incidents that the tribunal deemed accidental, innocuous, and not of a sexual nature. The email read, "Can you please complete the following? The solution is currently used by XX agris companies and YY barge lines in corn cargoes in south-north flows in the 4 waterways. So it's clearly work related. So needless to say, the Employment Tribunal found against the claimant on her sexual harassment claim. The judgment said that the claimant's case rested on interpreting seemingly innocent interactions between her and Mr. Goulandris and finding a sinister motive in them. In our judgment, this led her to take a skewed perception of such interactions. Now, interestingly, I did think when I was drafting this, what if Mrs. G had said, well, my interpretation of that email was related to a disability I have. I couldn't think of what disability it could be, but then that would have complicated the situation, wouldn't it? But you can see these things happening. But I thought it was quite amusing. And the tribunal said it's just extraordinary. The claim was just, what she was saying was just extraordinary. So I did think that was quite amusing. Right, a skip and a jump then through some changes to legislation. The first one then is that I want to bring your attention to is the new law giving giving flexible working rights, of changing the existing flexible working regime. So it's the Employment Relations Flexible Working Act 2023, and it has been granted royal assent, so it has become law. The Act enables employees to make 2 flexible working requests in a period of 12 months rather than the current 1. And it requires employers to respond to requests within 2 months of a request being made rather than the current 3 months, so in a quicker period. Employees will no longer have to explain the impact that granting the request would have on their role and how that might be dealt with. And in addition, managers will not be able to refuse a request until they have consulted. So another obligation on the employer, consulted with a member of staff about it. At one point, the day 1 right was mooted. As soon as an employee joins an organisation, it was mooted that they could then bring a flexible working request. However, that is not expressly stated in the Act. Employees therefore still need the 26-week service before they can make a flexible working request. But the government have said that they will deal with the day 1 request issue through separate legislation, which we haven't heard anything about at the moment. Conciliation Service ACAS is currently updating its statutory code of practice on handling flexible working requests, and the new code will address the changes in the law alongside the way work has changed since technological developments have accelerated in the COVID pandemic, increased remote and hybrid working. So not a huge amount of change on that, but it just means really that more obligation on the employer to deal with the requests more quickly. Also, they may be faced with more requests within the 12-month period. And they will have to consult with employees about their requests. It might be worth us looking at the moment at how many flexible working requests we're receiving, how long they're taking to be dealt with, and see if we do need to actually push some changes in how the requests are being dealt with. This law comes into force in spring next year, we anticipate, so we've got a bit of time to have a look at how we're dealing with the flexible working request now and see what changes we need to make.
I was going to say, Keeley, we had a couple of questions about that. I think you've just answered that. So Jordan was asking, is it enforceable now? So the flexible working, no, not till spring.
Not till next year, but you can start now if you wanted to. It will be in. Not the day one right. I don't know when that or if that will come in, but yes, it will be in next year. So it's worth just looking at how we're dealing with things at the moment, see if any changes need to be implemented by next year.
Fab, thank you.
Another one which may or may not be of interest to you, Eloise, is the new law giving temporary and agency workers the right to request more predictable hours. So the Workers' Predictable Terms and Conditions Act 2023 passed through the House of Lords on 18th of September. When enacted, it will give people in atypical work, such as 0 hours or temporary contracts, the right to request a more predictable working pattern. Labour peer Baroness Anderson says that the Act will give workers additional predictability and security in their hours and income at a time when many are struggling with a rising cost of living. She said workers will be better able to secure employment that suits their individual circumstances, helping them to feel more satisfied at work. Workers will be empowered and encouraged to talk to their employers about their working patterns, safe in the knowledge that starting this conversation will not result in any detriment. Don't know how employers are going to feel with it, losing that flexibility that obviously they rely on, particularly in some sectors. Key points to note then, the qualifying period of service to make a request is likely to be 26 weeks, although because we're talking about 0 hours and atypical workers, it will not have to be continuous service. The right will apply to the following: workers whose existing working patterns lack certainty in terms of length or times of work, workers on fixed term contracts of 12 months or less, and agency workers who can make their request either to the agency or to the higher up, provided they meet certain qualifying conditions. Other key points of the new right is that a maximum of 2 applications can be made in any 12 months period. The application must specify the change being applied for and the date it should take effect. The requested predictability could relate to hours of work, days of work, or period of engagement. Employers will be required to deal with any requests in a reasonable manner and notify the worker of their decision within 1 month. So it's a quick timescale. And requests may be refused on any of the several specified grounds. And they're the same grounds as the grounds you can reject a flexible working request. So additional cost, ability to meet customer demand, impact on recruitment, impact on other areas of the business, inefficiency of work during the proposed periods, and planned structural changes. So they're the six grounds on which you can reject the request. If a request is granted, then employers must offer the new terms within 2 weeks of granting the request, and employers cannot make detrimental changes to other contractual terms at the same time as making the changes required as a result of the approved request for predictability. So ACAS will be producing a draft code of practice to accompany the new law for consultation in the autumn, so any time now, which will obviously provide guidance on how to handle these requests.
Great. Keeley, is there any clarity on the definition of work of the worker?
Yeah, so it will be the same as in the working time regs, all of the work legislation. So it's very much, it's not full employment status. So it'll be somebody who has got less control, or you've got less control over than an employee. They're not subject to your disciplinary and grievance procedures, but they are being paid through PAYE. So it's this gig economy issue status still. So we've got 3 statuses. We've got people in business on their own account who are truly self-employed. Then we've got the worker status who are protected from discrimination and also have the right for holidays and minimum note, just holidays mainly just holidays, and don't have the full statutory protection rights. And then obviously we've got employees who have full statutory protection rights, not to be unfairly dismissed after 2 years, etc. So so they will be on payroll, but you have, as an employer, have less control over workers, maybe casuals. You offer them work, they might accept it, they may not, you don't hold them to that. It's quite a flexible arrangement.
Okay, and Kate's also asked, why would this be 26 weeks when other flexible working requests going through would be a day one right? Sorry.
Yeah, well, we don't know whether the day one right is going to come in. It's something that has been mooted as a possibility, and lots of organisations have talked about it, but it isn't in the legislation that's been enacted. So we don't know whether that day one right for flexible working has come in. Why the difference is, if it comes in, why there's a difference between that and this and these and the workers, I don't know. I don't know.
Okay. Thank you.
Yeah.
I think that answers all the questions on that one.
Okay, so then the introduction then of the legal definition of bullying. We at the moment do not have a legal definition of bullying in the workplace. So when a claimant brings a claim in relation to an allegation of bullying, what they do is they rely upon the implied term of trust and confidence, and they say that the employer has acted in a way that undermines the trust and confidence in the employment relationship by bullying me or undermining me in this way or that way. So the bill that is proposed, the Bullying and Respect at Work bill, is something that has been pushed by lobbying bodies for a legal definition of bullying. So that will then enable people to say, or claimants to say, I have been bullied, it satisfies the definition in this legislation, and I can therefore bring a claim relating to the breach of that piece of legislation. So it will make things potentially easier for claimants to bring claims in relation to bullying allegations. And then the next legislative change relates to neonatal leave and parents' redundancy protection. Under the latter, a pregnant woman and new parents will see an extension of existing redundancy protections to cover pregnancy and a period of time after parents return to work. Currently, parents are only protected from the date a woman becomes pregnant to the date she returns from maternity leave. So maternity leave period is protected, as is the shared parental leave, as is the adoption leave, and obviously the confinement period. However, there is very little, well, there's no protection, additional protection for when a parent returns to work. So the proposal is additional protection when the parent returns to work. The Neonatal Care Leave and Pay Act will allow parents whose newborn baby is admitted to neonatal care to take up to 12 weeks of paid leave, in addition to other leave entitlements such as maternity and paternity leave. The length of the leave and statutory neonatal pay will be based on how long their baby receives neonatal care, and will apply if their baby receives neonatal care for more than 7 continuous days before they reach 28 days old. The government will need to introduce secondary legislation to implement these new entitlements on a date yet to be announced. So expectation is that this is going to come into force again next year. We've got the leavers bill, the carers leave bill, which many of you, I'm sure, will have heard about. So this will give a carer 5 days of unpaid leave, in addition to the other leave entitlements that are in existence at the present time. So any employee who cares for a friend or relative will be able to take up to 5 days of unpaid carers leave per year on top of the usual annual leave allocation. it's unpaid. It's an unpaid right, but obviously an employer has discretion, or it's up to them if they want to pay an additional amount for those leave days. According to the Carers UK charity, an estimated 2 million UK employees are currently juggling paid work with unpaid caring responsibilities. And I'm sure you hear about it all the time when people, your employees, are saying, I'm caring for my elderly relative, I need some time off. So this, I think, will be used. The Information Commissioner's Office has also published a guidance for employers on responding to data subject access requests. The Information Commissioner's Office received 15,000 complaints relating to subject access requests last year, alleging employers haven't dealt with them, or they haven't dealt with them in the time scale. I'm seeing so many more of these from claimants who not only say raise a grievance or appeal a decision, but they also then at the same time put in I'm very sorry about this, put in a data subject access request. So an employee is then faced with having to deal with the grievance as well as deal with the data subject access request. They have to deal with the request within a month. So it is a short time scale. It can be extended, but under limited circumstances. And what an employer may not realise is that the request can be quite an informal request. So it can be done over social media, WhatsApp, text. It doesn't have to specifically state this is a request under the data protection legislation to be caught. So just be aware of that. And it might be worth, if you ever did receive a request from an employee for their personnel file or for any other data that's personal to them, to have a quick look at this guidance, because I think it will be quite helpful. Lastly then, I think it's the last one, changes to working time records and calculation of holiday pay. The proposal is that employers will no longer need to provide records of employees' hours. At the moment, there's a requirement for employers to keep these records of hours worked by employees, predominantly to ensure that the 48-hour limit on working hours isn't breached. It's a health and safety requirement that potentially is going to be removed, which will remove quite a lot of burden on employers who are having to keep quite onerous records. Consultation closed in July, and we'll see where it goes. It's part and parcel of these initiatives to remove or reduce the amount of legislation that's come in through Europe over the years. So we anticipate there will be a fair few changes in relation to working time and holidays and such over the next couple of years, as that legislation that came in from Europe is reduced, and hopefully will ease the burden on employers quite a bit. And also back to the introduction of rolled up holiday pay, we're having an awful time, I'm sure you're experiencing it too, with holiday pay, because of the fact that part-time workers case came in last year, where we should be using 12.07% to calculate an employee's holiday entitlement who works 0 hours or casual work. Very tricky to make holiday pay calculations at the moment. We should have seen some legislation in the summer, but we haven't, about whether or not we can still use the 12.07% calculation to calculate holiday. But as I say, that's not come in. But there is this that states that we may be able to use the rolled up holiday system again, which we can't do at the moment. So we actually roll up the holiday pay into the hourly rate. So we ensure that 0 hours workers, casual workers, are being paid their holiday pay within their hourly rate. So we don't have a continuing liability, and we don't have a system where we're having to try and calculate what holiday they're owed and then tell them the days that they can take as holiday. So again, that will hopefully ease our burden somewhat, but let's wait to see if and when it comes in.
I was going to say, Keeley, there's just a question on that. Caroline was just asking about holiday pay. Is the method of calculation going to change? You know, those who work within turn time, for example, can have higher
that's
holiday
the case,
pay than those who are in full time.
Yeah, I know, it's just madness, absolute madness. So yeah, I mean, at the moment, that is the position we're in because of that part-time term time workers case that we went through in the previous update session. I can reissue the notes on that, but ultimately we hoped that there was going to be changes, and we were told there were going to be changes this year as a result of that case, so that we could then again use a 12.07% calculation. But as I say, that hasn't come in yet. So fingers crossed we'll get something by the end of the year. Who knows? Yeah, it's a tricky one for term time contracts, employers of people on term time contracts to calculate those holidays. And yes, I agree, they're getting far more holiday than pro rata they should be entitled to. Yeah. And then just lastly, the proposal is to reduce the length of non-compete clauses in employment contracts to 3 months. So at the moment, the standard is 6 to 12 months non-compete restrictions on employees' activities post-termination of their employment. There has always been talk about reducing those non-compete clauses and question whether they're reasonable anyway. But the proposal is to remove or reduce the length of those non-compete clauses to 3 months. And that concludes the session. I'm sorry, I've run over a bit. So apologies.
Okay. I was going to say, Keeley, that was really interesting. So that's okay. I think people would rather we overrun and actually answer questions and go through things properly. Yeah. Knowing that they've got the recording, if people need to go, they can rewatch what they've missed. So no, thank you so much. Thank you for a really fantastic update. Always informative and easy to digest and humorous in the right places.
I know. So, I mean, that case did have me laughing. I was thinking, oh my goodness, can you imagine defending that case as an employer and thinking, what on earth is going on with this woman?
Definitely. So thank you so much. Everybody, I'm ever so sorry that we missed the summer update. Keeley and I will absolutely make sure that we're on things for you. But if there are any topics that you'd like us to cover and you want, other than employment law, you want the HRHuddle to have an expert speaker in on, then please just send me an email or give me a call and I can get things organised. So lovely to see you all. Thank you very much, and I will sign off and speak to you soon. I will send out the recording probably in about a week or so when we've had it edited. Okay, so thank you so much, and I will speak to you very soon.
Thanks.
Take care. Bye.
Bye.